And good morning.
Good morning, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the Court, my name is William McDonald. I'm here on behalf of the appellant in number 6 on the calendar, entitled Dr. Michael J. Golia against the State of New York. In that case, we are asking this Court to reverse the September 30th, 2014 order of the Court of Claims, which denied appellant's motion for leave to file a late claim. Also, on number 9, we're asking the Court to reverse the holding in the October 20th of 2016 order from Judge McDonald.
That's the motion to re-argue?
Yes, Your Honor. And that dismissed counts 3 through 9 in the appellant's motion, in the appellant's amended complaint, but we're asking to affirm the denial of the defense's motion to dismiss counts 1 and 2.
So as to case 6, which is the Court of Claims matter, correct?
Yes.
And in that case, the claimant was denied leave to file a late claim, correct?
Correct.
And tell us why you believe the judge wasn't within the judge's discretion to do what the judge did.
Yes, Your Honor. Well, it's within the judge's discretion, of course, whether or not to grant the motion for the leave to file a late claim. But the exercise of discretion in this case was improvident because she misapplied the standard evaluating the appearance of merit to the claim. All right. Under Court of Claims Act 10, Section 6, the state actually conceded in their motion to oppose 3 of the standards by which the court's supposed to consider granting the motion for leave to file a late claim. That included the fact that they conceded that there was no prejudice to the state. They conceded that they had notice of the facts underlying the complaint. But what the court focused on instead was she held the Santana standard, which is supposed to evaluate the claim's appearance of merit, as if it was not frivolous or groundless or legally defective, and she elevated that standard to a likelihood of success on the merits. When I look at the Santana case from 1977, the Court of Claims does an extensive discussion as to the history behind the new Court of Claims statute in that case. And they said that the intent behind the legislation was to expand a claimant's ability to bring an action before the state late, rather than restrict it. So right away from the beginning, we should be looking to expand the claimant's ability to file a late claim.
Did the court, if you don't mind my interrupting, did the court cite to Santana in this decision?
I believe she did, Your Honor.
Yeah. Mm-hmm. So does that suggest that she was cognizant of the appropriate language standard?
It may be, Your Honor. She didn't quote She didn't quote the entire case. She didn't discuss the fact that reasonable cause was the ultimate burden of proof that the Santana court enunciated in that decision. The Santana court also said that the level of proof should rise a little bit to the level of that required to vacate a motion for a default judgment. And the court didn't cite that language in the decision. What troubled the appellant in this case was that the court also adopted certain findings of fact in an initial motion to dismiss, essentially, that the state made. While the state opposed the motion for leave to file a late claim, the court treated it as if it was a motion for summary judgment or a motion for... One of the most glaring examples of that is in evaluating the defamation claim. She explicitly ruled that the word termination was not defamatory, while termination is essentially a term of art that is set forth in the residency agreements that the appellant signed. The word termination both in the Litch resident agreement and in the SUNY resident agreement has a specific meaning that the person's residency was terminated prior to the end of the contracted term. So that contains a very negative connotation using the word termination. But instead, she simply adopted the statements made in the affirmation in opposition of the state that said termination is not a defamatory word. She adopted the state's statement of fact that it was an internal document only that said that the claimant was terminated or fired or non-renewed for failure to meet standard.
Counsel, what's the time frame of when the actions arose and the reason or the excuse for the delay?
Certainly, Your Honor. The residency period started in April of 2010 when the claimant signed the residency agreement, and it terminated on June 22nd, 2011, when the SUNY agreement had the expiration of its term.
Right, and the application for extension of the time to file wasn't until 2014, right?
Correct.
So what's the reason and the excuse for such a long delay from that part of the claim?
Well, the excuse for the long delay, Your Honor, is...
Don't you need to show, I know it's not the sole factor, but don't you need to show some basis as to why it's almost slightly less than 3 years, right?
Correct.
The statutory period to file a notice of claim.
Yes, it is.
Okay, so what was the reason that was articulated? Because that's one of the factors that the judge, I believe, can consider in this determination.
Correct.
What's the compelling reason why it took almost 3 years for this claim to be filed, or the request for...
Certainly. The compelling reason why it took almost 3 years to bring about this action is because it took almost that long for the claimant to actually start to reveal some of the facts underlying the claim. An example of that is the word termination appearing in the Department of Labor records. We didn't find out that was in the...
The claimant knew that he was no longer employed. You're saying the key date is the date that he found out they used the word terminate rather than when they didn't extend. I guess it's a, what's the word? It's a semantic argument. Was he terminated? Was he not extended? Right? I mean...
Right. They also have to follow the rules.
But he didn't grieve anything. He didn't follow the procedures that he had the right to follow when he did not get renewed, either with Long Island College or at the state level, right?
Well, the unfortunate part is they never gave him the opportunity to grieve that, because what they essentially did was they issued a conditional notice of non-renewal. That's something that Judge McDonald held in the Queens Supreme Court decision on the first motion to dismiss in that case.
But he had the residence agreement, right? He had it.
Yes.
Presumably he read it, and it says it's the sole and exclusive remedy available.
That the grievance procedure kicks in if essentially you have a notice of adverse action. The notice of adverse action is an actual notice of non-renewal, or placing the resident on probation, or terminating the resident's residency prior to the end of the year term. A conditional non-renewal is supposed to trigger an obligation on the part of the hospital to provide a plan of remediation, to articulate what standards the candidate must meet in order to progress to the next year.
So why
And
didn't
this
he
was
do
never
that?
done.
As soon as he was terminated, why didn't he just go in there and say, look, I have these due process rights, you didn't notify me, you know, this is, I want to pursue this. Why didn't that happen?
Well, he was still trying to get into other residency programs at the time, and that's when we were applying to almost...
And he didn't grieve it.
It didn't constitute an acceptance of the decision, especially because he maintained informal discussions with SUNY downstate through prior counsel. I understand that the standard, I believe legally, is that informal negotiation with the state by itself is not a reasonable excuse. However, I think it still does not constitute an acceptance of the decision by the state to essentially terminate the agreement. The key here, though, is any termination of a residency agreement or any notice of adverse action must be accommodated in the ACGME guidelines that applies to both the Litch program and the SUNY program, because it's an overall accreditation. It also applies to the Litch residency agreement. You can see that on the record at 227 and 228 in the Court of Claims action. And when you go to the record at 231 as well, you've got the Litch due process policies and procedures. They all say the specific word, not that it may, not that it should, but that the notice of the right to appeal must accompany any notice of adverse action. So what we have is...
Does that mean he still has the right to appeal because the notice wasn't sent? So the time has never run? Is that your position?
Well, yes, Your Honor. The time has never run because he was never adequately notified whether or not this was an adverse action. We contend that it wasn't an adverse action, that a plan of remediation will be offered.
How did SUNY terminate him? Because I guess part of the confusion here is Long Island College gets taken over by SUNY, which now brings on a whole panoply of other rights that he may have under a state system. So how did he get notified? My understanding is that he had a short-term agreement with SUNY, and then that wasn't renewed. So is that the reason why he didn't get this?
Correct.
There was of adverse termination or the like.
Yes, Your Honor.
What were his rights when that agreement didn't get extended? What should he have done?
Under the due process policies and procedures of the state.
Your response to that is?
My response to that is we have nothing in the record that constitutes a notice of adverse action in any way. What we have in the record most closely resembles a notice of conditional non-renewal. The conditional non-renewal, when you look at the due process policies and procedures, has no grievance procedure.
Where is the SUNY notice? Is there a SUNY notice in the record? I apologize. I should know where.
There is no SUNY notice in the record.
So all it is the extension agreement. When they took over, they had all of the new employees sign various documents. So that's the operative document between him and SUNY?
Yes, Your Honor.
Essentially? Okay.
Of finding, Your Honor, because it still didn't have a notice of the right to appeal attached to it, so I would contend that it wasn't a final decision at that point. It also is essentially moot because it was given less than 6.5 months prior to the expiration of the one-year term in the residency agreement. The residency agreement says that if a resident is to be non-renewed, they're supposed to be given 6.5 months advance notice, and the February evaluation didn't do that. And in this case, the state and Litch, in their briefs, have adopted the notion that the November 15th, 2010 evaluation constituted a notice of non-renewal. So,
if I can go back to the defamation just for a moment, assuming you're correct that the Court of Claims didn't give the proper import to the word termination, is there still a pleading problem here with respect to the publication element of defamation? Is there an identification of a particular individual to whom this incorrect information was actually published?
well, I know that's been raised in all the papers, Your Honor. The problem with that is the claimant has essentially pleaded everything that was possible to plead. And we cited a case in the brief from the Northern District of New York that said if the claimant has pleaded everything that is possible to plead, and it's impossible to find out the name of the exact person that the information may have been published to, There's no other standard that can apply at this point. Perhaps we could learn through discovery the specific names of some.
Yeah, we don't know if any of these 150 places that applications went out to, whether any one of them ever even contacted, I guess, SUNY to find out any information directly from SUNY.
Correct. We don't know that right now, but the judge at the Court of Claims level adopted wholesale the affirmation of Dr. Wadowski, who, as the designated institutional official, said that nobody had contacted either SUNY or Litch to verify the claimant's status within the residency program.
You made a FOIL request?
I'm sorry?
Did you make a FOIL request?
We made a FOIL request to the Department of Labor, Your Honor, and that's what was revealed to us in October of 2013, where we received documents that showed the Department of Labor's communications said information has been received, that you were terminated for reason other than a lack of work. There was another screen print that contained the word fired. There was another screen print that contained the word did not meet standard. So termination was the word that was contained on the SUNY document, the House form that we cite in the briefs. However, the publication in the Department of Labor already has 3 different iterations. So for that, we allege that it has been a continuing publication and not subject to the first publication rule, because the actual form of the defamation is changing, yet it still has the same detrimental impact on the claimant.
But isn't there a qualified immunity there? I mean, they're doing essentially their job in assessing whether they're eligible for the unemployment benefits, right?
And I would disagree with that, Your Honor, for the reason being that this was an extra, let's say, an extra communication to the Department of Labor. This transmitting a false statement that has such a detrimental effect on someone and creates a permanent record within the Department of Labor is not a regular communication between 2 departments within a business duty.
Don't you have to show malice, actual malice, if there's a qualified immunity?
We can terminate that with a qualification of malice as a proven fact, I believe, is premature. The Court of Claims is certainly entitled to rule that a qualified privilege exists after trial, but to dismiss this notice of motion to file a late claim by holding that the qualified privilege extinguishes the defamation cause, I believe, is premature, because she's accepting an affirmative defense before any proof has been offered.
On the tortious interference with prospective contractual relations, and I guess now we're in case number 9, how does that claim survive if there is not an identification of a specific third party who has said that because of the information provided by SUNY, we have not entered into contractual relations?
It survives at the pleading stage, Your Honor, because in those causes of action, we allege that the economic opportunities existed with the Mount Sinai School of Medicine and with North Shore. We also have a clear record of false information that is defamatory and, in fact, devastating that exists in the Department of Labor records. So at the pleading stage, it should not the claimant should not be required to, let's say, submit the level of proof that
So you're
would
saying
be...
it's more of a 3212 issue than a 3211 issue?
Exactly, Your Honor.
And at the SUNY, I guess the trick here is, at the time that he signed it, it's not for a year. He signs it, and they change the date. It ends 6/22/11. Then they talk here, all appointments are for a term of 1 year, and each resident must be reappointed for each subsequent contingent upon ... all residents, and apparently the time frame for when he would get notices was already up if you were to follow the letter of this agreement. So the question becomes, a resident who fails to meet shall be notified by his department in writing of the intent not to renew the contract. So was that the conditional letter that was sent by Litch, in effect, the notification under the SUNY agreement?
Frankly, we don't know what the SUNY took as the notification, Your Honor, because as you pointed out, the SUNY record can given a legitimate notice of non-renewal to the appellant. He could have then grieved it and had a hearing at the ad hoc committee level.
I guess the problem, he had that letter of their indicating their intent not to renew, right? So you're saying, and now he signs an agreement that's ending in six or 7 weeks. And then at the end of the 7 weeks, how is he notified? He's not given a new agreement. Is that the notification? Is there anything in the record that says you're not getting a renewal? Is that's your point? He never got, other than the conditional letter of non-renewal, that's all there is.
That's it, Your Honor. The record is actually barren as to anything that says you're done, we're not renewing the contract. And in fact, I believe the claimant had an expectation that he could have still been renewed by the fact that SUNY offered him that contract with only 6 weeks left to go. If he performed so
Well, they did it, I assume.
It's unfortunately we don't have enough in the record to be able to determine what
Fair enough.
SUNY's standard was, Your Honor. An additional point that I just want to make is that a lot of the justification between Judge McDonald's decisions and Judge Soto's decisions in dismissing the defamation actions, the tortious interference with contract actions, the negligence actions, stem on their interpretation that Litch ceased to exist as of May 2011, when in fact there is nothing in the record to establish that. What we have is the SUNY agreement with the claimant that is dated from May 1st, 2011 through June 22nd, 2011. We have statements in the record that the asset acquisition completed itself on May 29th, 2011, but those are simply representations from counsel. We have nothing in the record by way of an asset purchase agreement, articles of dissolution, anything to show that Litch didn't exist anymore.
So what is the basis that they're depending on? What they have proffer as a what?
Exist anymore after May of 2011, it could not have been held accountable for anything that happened after May of 2011. So if we're arguing that
But
defamation...
based on what? Based on what? What was Judge McDonald's basis for that?
His basis for that was the statements from Litch's counsel's motions that said that Litch ceased to exist in May of 2011 after the acquisition took place. So based on that, the judge held that if we're arguing in those Supreme Court cases that the causes of action accrued in 2013, that they couldn't have accrued as a result of Litch's actions because Litch didn't exist anymore. And concomitant to that, the doctors could not have committed actions on behalf of Litch to hold Litch under a respondeat superior liability theory in 2013. However, in one of the unreported cases that Litch offered in the fourth appeal in their brief, it's a miscellaneous court decision that discussed that the judge vacated the asset purchase agreement that authorized the transfer of assets as late as 2014 because of the intervening action that was filed by the New York City Public Advocate. So what we have is confusion in the record that Litch could have existed as late as 2014. We also have a fax header on the top of the House form, the one that says termination under the allegation for the complainant, that says it's got a Litch fax header on it, and it's dated January 24th, 2014. So if Litch doesn't exist anymore, how is its fax header appearing on the House termination form as late as January 24th of 2014? So I think that Litch and SUNY are inextricably intertwined in this controversy, and as kind of a superseding action, SUNY has acknowledged, both in its briefs and in the record, that it assumed all the liabilities for Litch when it did the asset acquisition. So, at least as far as the Court of Claims arguments go, Justice Soto's holdings related to dismissing the, let's say, the appearance of merit in the claims because actions were committed by Litch. Well, those actions by Litch are still attributable to SUNY pursuant to its assumption of the liabilities.
And with that, I'm going to have to shut you down. So,
All right.
Thank you very much.
Thank you very much, Your Honors.